Thank you for coming. I'm glad that there's interest in AI regulation. It's an important subject, and we're happy to be here. My name is Scott Starbird. I am Chief Public Affairs Officer at Databricks. And I'm thrilled to have with me today Aaron Cooper, who is the head of global policy at BSA, also called the Software Alliance. And for those of you who don't know, BSA is the leading advocacy organization for the enterprise software industry. We're going to divide this session into two pieces. The first one, I'm going to give just a quick overview of our perspective of AI regulation as it's likely to apply to our customers using our platform for a more or less typical use case. And I'm going to focus only on things that have already been enacted. And then we'll save for the second part a Q&A session with Aaron, who will have a bit more of a big picture view of what we think might be on the horizon and how that horizon might be evolving. Any discussion of AI regulation, I like to begin by pointing out there's a lot of law on the books already that's not AI specific, but that applies to AI. So just a few examples, the privacy regulations apply to AI. The data minimization requirements, the data subject protection requirements, the anti-profiling, opting out requirements have some applicability to AI. Plus, there are laws against discriminating against protected groups for important services. And there are laws that protect consumers in the financial services area, copyright laws that protect against infringement, all sorts of criminal laws. It doesn't matter what tool you use to commit the crime. So cyber hacking, for example, or fraud of any kind that's illegal already. It doesn't matter whether you use AI or not, it's still illegal. So what is in place that is specific to AI at the moment? By far the most prominent piece of regulation is the EU AI Act, and we're going to spend a few minutes on that after this. Then looking at the US, at the federal level, there's been a lot of activity in terms of bills introduced in Congress, but no broad regulation passed so far, in part because of the certain degree of dysfunctionality in our Congress. But there's been a lot of activity at the federal level in the executive branch, spurred largely by the Biden executive order last fall. And I have another slide on that in a moment. So we'll skip, actually, let's, completing this one. At the state level, there's been a flurry of activity. I think there are hundreds of bills in process right now. There have only been a few that have actually been enacted, and they primarily are fairly narrowly targeted. So for example, there are laws relating to facial recognition and the use of AI in employment decision-making and things like that. But there's a noteworthy exception to that, and that is the Colorado AI bill that was just signed into law. And that is, like the EU AI Act, it's fairly broadly applicable, and it is risk-based. Fortunately, it largely, not entirely, but largely falls within the framework of the EU Act. We're hoping that that will set precedent for other states, and hopefully even more so in terms of the alignment with the EU AI Act. And then there are some laws in other countries that we don't feel have a lot of general applicability to us or our customers as of yet, but we'll monitor, and I'm going to ask Aaron a lot about what's going on in other countries. So what do policymakers think about? What's important to them when they think about regulating AI? I'm just going to touch on a couple of these themes and then talk about it a little bit more in the context of the EU Act. But they care a lot about harmful content, particularly deep fakes. They care a lot about algorithmic discrimination. That's the main subject of the Colorado AI Act, for example. And then they care about protecting privacy rights, maintaining data security, and protecting and addressing IP rights. So back to the federal government for a minute. The Biden EO triggered a flurry of activity, including, in particular, a lot of guidance for use of AI within the federal government. There was an extensive memo issued by the the MBO, the Office of Management and Budget. And in addition, there's some reporting requirements, some of which are already in place, relating to frontier models called dual-use foundation models under the EO. So developers like Databricks, with respect to DBRX, if it qualified, would have had to report the development if it were a dual-use foundation model. It was not. And then also the cloud infrastructure providers are required to report if they are aware of a large training run that is sufficient to potentially be used to train a dual-use foundation model. The definition, by the way, of the dual-use foundation model is any model that used compute greater than 10 to the 26th flops or integer operations that could be modified through rulemaking over time. But so there's a big hiring spree as well. The EO called for putting in place chief AI officers throughout the federal government. So if you have, there's a lot of talk about AI causing job loss, but at least in the federal government right now, and in many other areas, there's a big demand for AI experts. Any one of you could probably qualify. So why are we going to focus on the EU Act? It is the first, as I mentioned, the first globally applicable comprehensive AI regulation. We think it's going to set precedent for other regulations to come here and elsewhere. And we believe that most AI regulation, we're hoping, will fall within that framework. So our mentality is if we really focus in on the EU Act and adhere to it, we're probably going to be okay. But I know part of my role is going to be monitoring other regulations that come into place and to try to test to see where they might go outside the framework of the EU Act. So a quick overview of how the Act works. Before I dive into this slide, the EU Act looks at two broad categories of AI. One is general purpose AI. That's the stuff that will apply to OpenAI, Anthropic, us in our model development area. I'm not going to talk about that today, not very much anyway, because I want to focus on how it's more likely to impact our customers using our platform. And for that, the second big bucket is this risk-based framework that is based on how the model is put into use, or the AI system. And they look at four general buckets of risk. I can deal with most of them quickly. We're going to focus on the high risk category. But unacceptable risk is simply prohibited. The high risk category is the one I'm going to focus on. That's where the bulk of the text and the burden applies within the EU Act. And we'll get to that in a moment. Limited risk is anything that's not high risk, but that interacts with humans. And there, the only substantive requirement is that the system make aware to the users that they are interacting with AI. And then finally, and this is the biggest bucket of AI applications, there's minimal risk category. And this would be, what's a good example? A location thing or something that doesn't interact with a human. A limited risk application would be, for example, a chat bot. But a minimal risk might be a recommendation engine, for example, in e-commerce or something like that. And there's no substantive obligation. So what's high risk? It's actually fairly complex, but helpfully there are two essentially lists in the Act that help point out what is high risk. In Annex 1, Annex 1 consists of a list of all of the risk-susceptible products that the EU already regulated. And these are mostly hardware related. Medical devices are an example. They require conformity assessments already in most cases. So if your AI system either constitutes a safety component of such a product, or it could be deemed to constitute such a product itself, then it's automatically deemed high risk. Then there's Annex 3, which is a little bit of a different kind of a list. It's a laundry list of AI applications. And examples of that would be AI systems that are used to determine access to fundamental services like healthcare or public housing or education, et cetera, or use in certain specific areas like critical infrastructure or in law enforcement, various aspects of law enforcement. Importantly, there's an exemption process, and this will be fleshed out with rulemaking over time. So it's still a little bit vague, but and probably court cases. I'm not real up on exactly how EU jurisprudence works, but the exemption process essentially, as I understand it, you can have an exemption if your AI system is used for a narrow procedural task, and kind of encapsulating the rest of it, if there's enough human involvement that effectively the human is making the final decision, and the tool is just being helpful, but the human has adequate oversight. If you feel you meet that exemption, then you need to document it through an assessment. You need to keep it on hand, and you need to make it available to the national governing authority upon request, and you need to register it in the EU AI high-risk database that is being put together. Just quickly, the general obligations to high-risk systems. A lot of it focuses on preparatory work before launch, focusing on having the right quality of data, doing risk planning, identifying the risks, doing extensive documentation of the way the model works. Fortunately, a lot of this is done with model cards today, but the Act definitely contemplates much more substance there. And then as of the launch date, there are several assessments that are required, potentially required. For all high-risk systems, a conformity assessment is required. I'll talk about that in just a moment. If access to fundamental public services are involved, then a fundamental rights impact assessment is required. And then if personal information is involved, then a GDPR data protection impact assessment is also required. You need to digitally mark the system as conforming and indicating that you've gone through the conformity assessment process. And then again, you need to register it in the database. Post-launch, I'll skip over that other than to say basically it's a requirement that you make sure that the stuff you put in place continues, that you're doing some monitoring, incidents, monitoring and reporting and alerting. The conformity assessment is essentially a verification that you've taken the steps necessary to conform to the provisions of the Act. And it is a self-certification. You need to make it available to the regulator upon request. There's a long list of specific things that you have to do, but they fall generally under the buckets of these bullet points that I've included here. It's all about risk planning, risk management, risk mitigation. There are penalties. The 3%, the greater of 3% or 15 million euros is the one that applies to violation of the high risk obligations. The 7%, the much bigger number, that's if you actually deploy an unacceptable or prohibited AI system. In terms of timeline, I should change the June to July. It still hasn't been published in the official EU register. Once that is done, and we expect that, I think, any day, that it's 20 days after is the official entry into force. And then these enforcement timelines go into effect based on that day. So think July 2026, that's the 24-month period. That's when the obligations on high-risk AI actually go into effect. The 12 months applies to general purpose AI, and the 6 months applies to prohibited AI. So until 6 months from now, you can get away with using prohibited AI, but don't do it. Just a quick note on the Databricks platform. We have tools across the platform that can help with virtually every aspect of not only regulatory compliance, but responsible AI generally. And a quick pitch, there's a session that Lexi is putting on at 5:10 in this building, I think on the next floor up, where she's going to go over with one of our security. Omar is here as well. Oh, is it in the other building? Okay, sorry. Well, anyway, don't go by. It's 5:10 though, right? Anyway, that's going to focus on the platform and its use for responsible AI. Prepping, I'm not going to spend a lot of time on this because I want to get to questions with Aaron, but we think the EU AI Act is probably setting the trend, and so a lot of that preparatory stuff is really important, focusing on risk planning, identification, mitigation, and then an important recurring theme that's going to pop up with all other regulations, many other regulations, is that if it's interacting with humans, you need to make sure that the users are aware that they're interacting with AI. That's kind of a given. It should be part of responsible AI anyway, but that's another thing. We can come back to this maybe with Q&A, but with that, I'd love to switch to some questions with Aaron. Aaron has been the head of global policy at BSA for a while. Before that, he was chief counsel for IP and antitrust in the Judiciary Committee on the U.S. Senate, and before that, he has had a significant career in law. And I'm going to start asking. Will I sit down? I feel comfortable standing at the podium here. So, Aaron, thank you again for joining us. maybe if you could start with just a little bit of a snapshot of what BSA is, what's it all about, and in particular, what are the activities of BSA relating to AI?
Sure. Thank you. Thank you very much. We'll have to talk later about how much of that slide deck I can steal and use at other times. That was an excellent overview. I was telling Scott before the session started that I was able to go to some of the other sessions this morning and just learning how what the different use cases are for cutting edge versions of AI and what the possibilities are is so helpful both from an understanding perspective, and it makes me optimistic about the future, which is also terrific. I spend a lot of time in country capitals, and the conversation there is usually either how do we make sure our AI is better than China's, or how do we make sure that robots don't take over the world? And what we really need, I think, is for people in those capitals to see what's here, to see the excitement around the way AI can be used for different industries to be successful, for industries outside of the tech space to be able to serve their customers better, have a safer workspace, things like that, that are real practical changes that are going to happen based on the work that Databricks and others are doing. In terms of BSA, so we're Business Software Alliance. Our companies provide enterprise services to other industries. So Databricks is kind of the platonic form of a BSA member, in that you provide cloud services and data services to different industry sectors. You develop your own AI, you incorporate AI and let customers incorporate their preferred AI tool into your services. And Databricks and our other BSA members, one of the things that they focus a lot on is making sure that the way that they're developing and deploying AI is done in a responsible and thoughtful way, and that's both the right thing to do for the world. It's also necessary because you're serving customers who are going to demand that kind of attention to detail and making sure that the way you're training is responsible. And that leads into what, from a BSA perspective, we've been advocating around the world on artificial intelligence, which is to try to not just focus on competition with China and not just focus on the real but far off risks of what general AI might do in the future, but instead think about what are those risks that we can identify today and take steps to mitigate so that we can actually improve the system, improve trust and security and reliability in AI. So things like you were referring to in the AI Act about making sure that if AI is being used in an employment decision, that the way you've trained the data or fine-tuned the data set is accurate and not perpetuating historical biases. Making sure that when you're deploying AI, that you're doing it in a way that also will be consistent with legal requirements and ethical requirements to make sure that you're not discriminating when granting a loan, things like that. And where we can get governments to focus on those issues and require steps of companies that are developing or deploying AI to have in place a risk management program to make sure that both on the development and the deployment side, that you're thinking through these issues and trying to identify what problems might arise and what steps will we take to mitigate them when we identify them. That's the kind of practical step that Congress, the EU, as they already have, state of Colorado, as they already have, and other governments around the world can look to as a way of regulating, not based on the technology, but based on the way it might be used.
You know, I'd like to just add that as a member of BSA, we really benefit from Aaron's team. He has this global team that feeds us a massive information flow, very, very well curated information flow about developments everywhere in AI, but in other areas as well. We talked about the EU AI Act. What's your thought in terms of what kind of precedent it will set? Is there a Brussels effect? Will it impact US regulation very much?
There's always a Brussels effect. One of the things, Scott was mentioning that I used to work on the Hill, and he's right. So I feel like I can say the odds of Congress passing things, you should always bet against it, right? Doesn't matter what the issue is, even if it's naming a post office these days, you generally want to bet against it. But in the EU, it's very different. Once they propose a regulation, eventually it's going to become law in some form. And to the EU's credit, in the process of creating the EU AI Act, it wasn't something that just happened overnight. They spent 3+ years having an expert group of civil society and academics and industry to talk through what an AI Act should look like. So it started with a conversation around what should the EU ban, and what sectors should it not be allowed in. And it shifted over time to what kind of uses pose real risks and how can we try to mitigate those risks. So I think it was a pretty thoughtful process that led to the EU AI Act. It's certainly not how we would recommend drafting it, but it's a fair compromise in a way of trying to make sure that it's focused on those high-risk use cases. One of the things that we saw from the privacy world, and this is the Brussels effect that Scott's referring to, is once the General Data Protection Regulation, the GDPR in the EU was enacted, we saw governments around the world, and now within the 50 states in the US, enacting similar looking privacy laws. So not identical, but very similar. And I think we're gonna see a similar approach with the EU AI Act. Hopefully somebody will put more consonants in their acronyms, because saying EU AI Act, or in the US it's the Executive Order on AI, so EOAI is difficult to say. But the EU moved on AI regulation sooner than they did on privacy regulation, and it's less solidified. There's more, I think there will be more issues that get surfaced and that policymakers around the world want to address. So I think what we saw in Colorado and almost saw in Connecticut was taking the EU AI Act as the base and then trying to identify what other issues they wanted to address. And I think we'll continue to see that develop in other places.
You mentioned privacy. So there is a national privacy bill that's kind of moving forward, APRA. And it has some provisions that deal with algorithmic discrimination. What do you think the odds are of that passing and having some impact on AI?
Well, I would keep my bet where I would about post offices and other bills. But one thing that that legislation does show, it's basically an agreement between the chairman of the Senate Commerce Committee, who's a Democrat, chairman of the House Energy and Commerce Committee, who's a Republican. It's really hard to work bipartisan these days. It's always been hard to work between the House and the Senate. Those two usually fight more than Democrats and Republicans. But they've come together on what they see as a good way of moving both privacy and AI regulation. I think it's unlikely that this year that moves forward, but it influences the debates both on privacy in the states and on AI regulation in the states. So the discussions around what that legislation will look like as it continues to move this year, even if it doesn't get enacted, will have an impact, I think, as we see more states look at AI regulation next year. And as right now we have, I think, 19 states that have privacy laws that look similar, generally similar in scope. But I think that's going to change. Going into next year, we still have 31 to go, and it's not guaranteed that they will all look the same.
No. We've kind of set ourselves up, haven't we, for a patchwork, given that so many states are controlled by the same party on all houses and the governorship, whereas the federal government is just the opposite.
Yes, and the rules in the Senate that make it so difficult to actually pass anything in the U.S. Senate, whereas in state legislatures, there's a much easier road to passing. You don't really need the same kind of consensus that you do at the federal level. Can I say one other thing on the Brussels effect on the EU? I think one other positive aspect of the EU having moved and has an AI regulation in place is when you think about what concerns do companies have in adopting AI solutions. One of the things that I always hear from companies is a concern about not knowing what's going to be allowed and not allowed. What's the overall structure going to be? If I adopt an AI solution today, am I going to be told tomorrow that I can't use it? And I think by having that law in place, even though there's still many steps towards really fleshing out what implementation will look like, we know what the general structure is going to be. And we know that, okay, there are some things that are completely off limits, but they're very limited about what that is. And for everything else, there's, as long as a risk management program is in place, even if it falls into the high risk category, it's something you're going to be able to do.
I think I know the answer to this, but just in case, is a major part of your advocacy to make sure that the different state laws stay within the same kind of framework?
Yes, I mean, consistency, both within the United States and also internationally, is really important. And it's really difficult to get laws to look identical. But if we can make sure that they are as consistent as possible, so that as you're thinking about developing a compliance program or putting a risk management program into place, you can calibrate it so it's going to work across jurisdictions, certainly across jurisdictions within the U.S., then hopefully between the U.S. and the EU. And then as we think about other G7 nations and other countries that look to G7 as a way of thinking about what their AI laws should look like, that there can be one risk management program that could apply for everything.
So outside the EU and the US, related to AI, is there anything in particular you have your eye on right now that you're worried about or hoping for?
Well, I worry about inconsistencies, like you were alluding to. I worry most about the possibility of, take in the US, one state requiring a company to do X and the other state prohibiting it, and companies being caught in between. But on privacy, and I think on AI, we'll be able to keep moving it in a direction that has some level of consistency if we're all working together. And it's important to remember, it's not just the tech community that cares about that. It's all the other industries that are taking advantage of AI solutions and don't want to have different capabilities in one place than another place. In terms of other geographies, there are elections in so many places around the world. I use the UK as an example. They've been putting out guidance for a while about AI usage, both within the government and also for the private sector. But after the elections that are coming up in early July, it's quite possible they'll look at turning that into something that is more legislative and more statutory based with requirements. Japan has been looking at this for a while, and so far in a good, consistent way with other like-minded nations. Yeah. But we always need to keep monitoring that to make sure that countries are rowing in the same direction.
So you're all about enterprise software. That's what we are, most everyone here. Although, and there are a lot of end cases that are consumer facing. But what about the hope that regulators make a distinction between the B2B space and consumer facing?
So I think that works sometimes and not other times, and it really depends on the context. But it is so important that regulators start to understand the different roles that companies play. Whether you're direct to consumer or business to business, there's the difference between whether you're in the AI context developing the AI system or deploying it. And as an implementer of an AI system, if you're using Databricks' tools, you might not want, part of your contract might be that Databricks can't be looking at the end result. Or you might want to, it depends on the situation. But where you're not allowed to look at the end result, you don't want the developer to have those obligations that are going to cause privacy and trade secret concerns. And trying to educate policymakers about that it's not just one company that is developing solutions and deploying the solutions and interacting directly with customers, but that there's a whole chain. It's a difficult process because, especially with elected officials, in addition to having to become re-elected officials, they are working on a host of other things, and getting into the details of how the technology sector works is a challenge.
Can I ask you to prognosticate a bit on, there's a lot of talk about regulation of open source AI, particularly at the frontier level. Where do you think that'll play out? How do you think it'll play out?
I think it's among the places where we see a lot of dissonance within policymakers. On the one hand, they are concerned that an open source model that is super powerful could be used by adversaries in bad ways. But I think they also recognize in the more immediate term that what an open source model can do is provide more competition in the marketplace, and that is good for the entire ecosystem. I think that is the position that's winning out in a lot of places. As we've worked in both the EU and in Colorado, in California now as well, where there were proposals that would have been virtually impossible for an open source AI developer to comply with because of some of the requirements that they had on developers. They've started saying, okay, except this does not make sense for open source. It does make sense for proprietary systems. And I think that seems to be the viewpoint that is winning out. It's, in the US, part of the executive order from the president required the Commerce Department to look at open source and look at whether what the advantages and disadvantages are. I think the fact that it's the Commerce Department looking at it will mean that they'll think about the competition-related aspects of it in a positive way.
Any thoughts about how we could coax policymakers to come to next year's summit and absorb this enthusiasm?
We often will take staff on educational trips to let them see some of the technology more upfront, so they have a better sense as to what it's like. But as elected officials, they are doing so many different things at once that it is really hard to catch enough of their attention. And things that seem like common sense from the way we all interact with the technology, for a lot of the policymakers, they have to do that on so many issues that it's always a challenge.
There were a lot of great lines for the keynotes this morning that I was writing down because I want to use them and talking to policymakers about why open source is important, and customizable models, and the whole bit.
And people conflate all the time open source software and open source models or open weight models. And I think one of the things that often happens is that jargon that we get used to using means different things to different people and in different places. So just take AI in general. If we're talking to the movie industry, they think about it from one perspective. If we think about it, if you talk to a newspaper industry, they think about a different perspective. The pharmaceutical industry from another, social media from another, civil society from another. Very few of them think about database management, but it's hugely important for companies to be more successful.
I think we've gone over time, unfortunately, so we need to vacate. But thank you very much. This has been enjoyable.
Thank you, Aaron. Thank you very much.